Hello and welcome to Calm the Farm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. We're doing part one of a two-part session on the podcast. It's all around how to get compliant with your privacy obligation in 2025, particularly as a result of the changes to the Privacy Act. This is part one, which goes through the changes to the Act and the risks that you may face in your business. Tune in and, as always, sing out if I can be of any further assistance or you have any questions. It's 8:55 a.m. You're opening the pharmacy. You've barely had a sip of coffee. A staff member's called in sick, the fridge is beeping, and then the phone rings. Hi, it's Joe. Just wondering if you can tell me what medication my wife picked up last month? And in that moment, you pause. Joe, you think he's authorised, but you're not sure. I'm a commercial lawyer working with pharmacy owners across the country, and what I've seen is this. Most privacy breaches don't come from bad intentions. They come from moments like this, everyday decisions made under pressure with good intentions but without clear policies. Today I'm going to take you through what privacy compliance really looks like in 2025, why it matters more than ever, the simple steps you can take to protect your patients and your business. Spoiler alert, it starts with getting your privacy policy out of the bottom drawer and making it something real, useful and compliant. So let's talk about why privacy matters more than ever in 2025. Earlier this year, significant amendments to the Privacy Act were introduced in Australia. The changes mean that pharmacies have to be more careful than ever with patient data. The key changes relevant to pharmacy can be put into three categories, and we'll look at each of these separately. The first one is more focused awareness and enforcement. The second one is tighter rules, forcing you to consider what's really necessary in your business. And thirdly, the risk, because right now the risk is higher than ever. So first, increased awareness and enforcement. Firstly, the legislation which commenced in June 2025 introduced a new tort, which is a statutory claim for serious invasion of privacy. This means that individuals can sue business owners if their privacy is intentionally or recklessly violated or misused in a serious manner, even if there is no financial harm. The maximum amount that can be awarded to a successful individual is just shy of $480,000. This means that if you do something where an individual's privacy may be recklessly misused or perhaps recklessly violated, even if that individual does not suffer financial harm, you can be found guilty of that offence and then the other individual gets awarded compensation. So you really need to be taking the time now to ensure robust data protection measures are in place to prevent unauthorised access or disclosure of personal information in your business. Secondly, there is stronger enforcement by the regulator, and we expect to see more scrutiny around privacy compliance, especially around how information is being collected, stored and shares. The OAIC, which is the Office of the Australian Information Commissioner, now has power to enforce privacy laws, including to investigate compliance, issue infringement and compliance notices, and impose penalties for breaches of the legislation. And on penalties, the maximum penalty that can be awarded for a serious interference with privacy is a staggering $3.3 million. Also, public inquiries can now be inducted to make the public aware of behaviour that warrants being in the public domain, even if it is not unlawful. So if you do something, even if that may not be unlawful, if it is questionable behaviour, puts privacy at risk, may be used as a case study, I suppose, a public inquiry can be conducted into that. And that is as allowed to happen. It also means that your reputation could be quite significantly harmed. So what does this mean in your business? You need to ensure your business is prepared to demonstrate compliance with privacy laws, as evidence of compliance can be requested at any time. So it's not something you can set and forget, say you'll worry about it later when you're less busy or when you've got less things to do. It's something that you need to be doing now because you could be called on to produce that information at any time. And if you fail to comply with the laws, you risk significant penalties and reputational damage. The second key area we're going to look at is the tighter rules and thinking about what's really necessary to be collecting in your business in terms of patient information and privacy information. So businesses under the new amended legislation must now only collect personal information that is necessary for their function or activity. Personal information that is collected should only be used or disclosed for the primary and original purpose for which it was collected. For example, if a patient provides you with their telephone number for prescription reminders, you can't then also use that number for marketing purposes, say if you've got a sale going on or a new catalogue's come out, without obtaining the patient's consent. So you need to be thinking about what it is that you're collecting and why you're collecting it, and what purpose has been communicated to the patient or the individual about the use of that data. You should leave this conference and review your data collection and handling practices, and we'll talk more about this shortly. The third area that we're going to look on that comes out of the changes to the legislation in 2025 is around risk. And let me say, the risk for privacy at the moment is higher than ever before, particularly when it comes to pharmacy, and there is an area of significantly increased risk. That area, of course, is around e-scripts and SMS reminders, as well as artificial intelligence. So we are used to pharmacies collecting pharmacy-specific data that they need to protect, such as Medicare details, my health record information, medication details, etc. However, a new risk comes from technology like e-scripts and SMS reminders. And of course, there is also the growing and evolving use of artificial intelligence. Under the new legislation, if your business uses AI decision-making tools in any way, shape or form, it must be disclosed in your privacy policy. So if you're putting a medical situation into ChatGPT, asking it to give some clinical information, maybe you're using AI to record your clinical consults, you need to make sure that is disclosed in your privacy policy. Further, as part of your obligations and in your privacy policy, patients must be informed about what kind of personal data is being used in automated systems and how decisions are being made using their data. So if we take the example of recording a consult, the patient needs to be made aware of what details are going into that AI recording and then how it's being used. If you are using AI to diagnose or put in a scenario for some ideas on how to treat, the privacy policy needs to disclose what data, what personal information you're putting in order to get those answers out of AI. Patients must also be given the opportunity to understand how that technology is used and allowed to question or challenge the decisions that are being made by AI. So this means you have to not only disclose that you're using AI, but you need to give your patient the right to challenge or question those decisions. What this means for you is that you need to walk away from this conference and consider how and when you use AI in your pharmacy. If you don't use AI and you're thinking, phew, don't need to update my privacy policy, that's good. However, AI does certainly have its advantages. So if you're not using AI, I still would encourage you to think about it in your business, but just make sure you're using it properly. If you are using AI, you need to go and review and likely update your privacy policy to make sure these matters that now need to be disclosed to your patients are included in that policy. When it comes to determining the purpose for which data is collected and for what purpose consent has been given, it isn't as clear as you think, and there are things you're probably getting wrong. In the risk areas, we spoke about that information can only be used for the purpose which it's collected. But have you actually ever thought about how you determine that purpose and whether consent has actually been given? To demonstrate the areas that often need focus, we're going to look at the top 3 privacy pitfalls in pharmacy, starting with scripting without consent. This is a common issue where dispensing is done or information is shared without clear authorization. Here's a scenario that will be familiar to many of you. A regular customer's husband comes in to pick up his medication. You've seen him before and he seems legit, but she didn't mention he'd be in, and last time he spoke to her, she mentioned they'd been having some arguments of late. So, does she know he's here? Do you hand it over? The issue here is that familiarity isn't consent. To be proper authorization and consent, and to ensure best practice of only releasing medications to authorized people, you need both a record of consent and a system to record who can collect on someone else's behalf. Even if he was the nicest guy on earth and things were swimmingly with them and they always came in together, or sometimes he popped in or sometimes she popped in and she always talked favourably about him, so on and so forth, that is not enough to demonstrate that there is actual consent. You need a record of consent where the patient needs to have expressly said that her husband or whoever it may be is authorised to collect the information, and then you need a system to record that so that when that person comes in, it is clear and any staff member on the floor that day can find out and quite quickly and know whether or not consent has been given. The second pitfall that happens in pharmacy is overheard conversations. So this involves phone calls or conversations that are simply not private. For example, a staff member takes a phone call, they're confirming a patient's prescription and details, which involves reading out the person's name, date of birth, medication, Medicare details. Seems innocent, doesn't it? Except all of the customers in the store now have those patients' details. And under the legislation, this constitutes a breach of privacy. So what do you need to do to avoid this? The pharmacist or whoever is taking the call could move to a quieter spot and ensure that all conversations involving data and patient information are taken in a private room, such as the consult room or the office. You could confirm the ID discreetly. So consider asking the questions rather than giving the answer. So this would involve asking your patient to confirm their name, address, date of birth, Medicare card, rather than reading that information to the patient. The key thing is to remember that being busy isn't an excuse. Even 10 seconds of exposure, that's a 10-second phone call when you're calling Mrs. Jones to confirm that her date of birth is XYZ and her prescription is for 2 months because she's going overseas, that can be a breach of the privacy laws. The third scenario or pitfall that we're going to look at relates to outdated privacy policies. Ever heard yourself saying something along the lines of, "We've got a privacy policy, but we haven't checked it since 2014. Or maybe you've said, when asked where you got your privacy policy from, "Oh, I just asked my pharmacist friend for theirs and took a copy and used it into our store." The risk here is that the policy in place is not compliant with the Privacy Act and the Australian privacy principles. So what do? You need to review and update your policies, and I've said that a number of times now. Ideally, your privacy policy should be updated on an annual basis or where there are key changes such as those that were introduced in June 2025. You need to consider how you store, use and share data. Make sure it is compliant and make sure your process of storing, using and sharing is reflected in your privacy policy. You also need to be asking yourself whether you've reviewed and updated your policy since the introduction of new technology, like e-scripts, SMS reminders, but more importantly, because of the specific provisions that now exist in the legislation, artificial intelligence. If you've got a dusty policy, you may as well have no policy at all. If it's not real and if it's not suited to your business, it's risky. That concludes part 1 of our 2-part session on the obligations under the Privacy Act. Hope you enjoyed it and are looking forward to part 2 next week. I'll speak to you then.